Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the May docket of the Tennessee Supreme Court at the Nashville Supreme Court building. Welcome to all of you who are viewing on live stream via the wizardry of our communications and IT departments. We're so pleased to have all of you who are here in person and those who are viewing by live stream. So I will say at the outset that we have some special visitors here today. The communications director, the head of that Department of Wizards, is here with some young charges. Samantha Fisher, our most excellent communications director. Director Fisher, would you please introduce to the court the young women that you have with you?
Good morning. It's a pleasure to be with you this morning. Thank you, Chief Justice Grundy. I am pleased to have my two daughters and the daughter of one of my closest friends here to observe court this morning. Annie Fisher, would you like to stand up for me? This is my oldest. She's 13, goes to JT Moore Middle School. Ms. Sloan Wilford, also 13 years old, a student at Harvard Hall. And my youngest daughter, Tess Fisher, who is a rising 7th grader at JT Moore.
Very good. We're so pleased to have all of you. Do we have any summer associates here today? If so, would you stand up? We want to get a look at you. All right. We may be asked, there may be a pop quiz after this, so thank you, and we're so glad to have you here today. Are there any other preliminary matters before we get started?
No, Your Honor.
All right. Mr. Hibner, you may call the first case.
Tinsley Properties, LLC et al. Versus Grundy County, Tennessee.
Good morning, Your Honors. Michael Catone of the Nashville Bar here today on behalf of Appellants Tinsley Properties, LLC and Tinsley Sand and Gravel, LLC. I'd like to reserve 10 minutes for rebuttal.
So what's the total time allocation?
I believe it's 35 minutes in total, so 25 and 10.
Okay. All right.
Thank you.
Thank you.
This case concerns the fundamental principle under Tennessee law that local governments are only permitted to exercise those rights that are specifically delegated to them by the General Assembly. There are two Grundy County resolutions that are at issue in this case, and they're specifically designed to regulate the location and operation of quarries, rock crushers, and gravel pits in Grundy County. And those resolutions are void and invalid for two separate and independent reasons. The first is that Grundy County relied on the County Powers Act in enacting the resolutions, but the County Powers Act does not provide authority for Grundy County to pass the resolutions in the first instance. And the second reason is that the resolutions are void and invalid under this court's substantial effects test jurisprudence, because in enacting these types of measures that are in effect zoning measures, Grundy County was required to follow the statutory zoning procedures that protect Tennessee landowners' rights to the use of their property, which Grundy County admits that it did not do in passing the resolutions. So on the first issue with the County Powers Act, I think it's important to start at first principles. And the first principle is that there is no such thing in Tennessee as an inherent local governmental power. Local governments only have the powers that are delegated to them specifically by the General Assembly. They don't have inherent power to do things like regulate land use, which is what the resolutions do. For the resolutions to be valid, Grundy County has to be able to point to a specific grant of authority by the General Assembly that empowered it to enact the resolutions, and it can't do so. Grundy County here has relied on the County Powers Act, Tennessee Code Annotated 5-1-118C. And I think it's important to understand what that statute does. So C1 of that statute authorizes counties to exercise police powers that are granted to municipalities. But it specifically says that that grant of power is subject to other limitations in the statute, including the limitations contained in C2. And C2 says plainly that those police powers, that delegation of police power, shall not apply to those activities, businesses, or uses of property and business occupations and practices that are subject to regulation pursuant to a number of regulatory schemes, including the State Clean Air Act and the State Clean Water Act. Now,
Subject in any way? Is that your position if there's a tiny bit of regulation under something like the Clean Air Act?
Your Honor, I think that the way the statute is worded is that if these activities are themselves subject to regulation pursuant to the Act, if you're required, for example, quarrying, any quarry operator in Tennessee has to go get a clean air and clean water permit. And that is enough to make quarrying subject to Clean Air and Clean Water Act regulation. If it's a necessary condition to be regulated pursuant to the Clean Air and the Clean Water Act to engage in a certain type of activity, then that activity is subject to regulation under Clean Air and Clean Water.
Isn't that a pretty sweepingly broad interpretation? I mean, if we adopt that interpretation, I mean, what activities, businesses, or uses of land could be regulated?
There are many things that are not subject to regulation pursuant to the regulatory schemes that are listed in the statute. I think a great example of that comes from the SNPCO case that we talk about in terms of substantial effects. That dealt with the fireworks ban. Fireworks, the sale and display of fireworks are not regulated under Clean Air or Clean Water or any of the other regulatory schemes.
But should we look at, what does it mean to be, I guess, subject to regulation pursuant to, right? Are we to look at kind of what the core activity is and whether that activity itself is actually being regulated pursuant to these other statutes, or is it enough that like some aspect of the activity, requires a permit pursuant to one of the enumerated statutes?
I think the way the statute is written, the way C2 is written, is it says those activities, businesses, or uses of property that are subject to, which means that if you want to engage in that activity and you are required to be under the regulatory scheme, then that would be enough under the plain language of the statute. I think a key point here is that Tinsley's not asking the court to apply a broad interpretation to this language or a narrow interpretation to this language. It's just asking the court to apply a reasonable interpretation of the words that were used. If C2 has a broad sweep, it's because the General Assembly used broad language in drafting it. And the court's charge here is to apply a reasonable interpretation to that language. And I think a thing that makes that
that is the question. Is that a reasonable interpretation if the regulation that is in place does not touch the kinds of activities that we're talking about here?
Your Honor, the regulations in place for clean air and clean water do touch quarrying. And the way they do that... I
don't mean touch the business in any way, touch the activity that is being that the county seeks to regulate.
I still think they do, and maybe it would be helpful to explain how this permitting process works. And so if you want to operate a quarry in the state of Tennessee, a quarry operator must apply to TDEC for construction and operation permits pursuant to the Clean Air and the Clean Water Act. And that's not a rubber stamp or it's not like getting a driver's license, right? Where you have a card that says, yes, you can operate a quarry. What happens is those permit applications have significant information in them. They detail how the quarry is to be constructed and how the quarry is to be operated.
But the regulations don't touch on where that activity may take place, and specifically what it might be close to, does it?
Those regulations don't touch on any business activity or use of property specifically. The way that they're drafted is they deal with sources of discharge of pollution, and then it's up to TDEC to determine which businesses, activities, and uses of property are subject to regulation under that statutory standard, which TDEC has done and has required quarries to go through this permitting process for decades. And on the permit, if the permit application is denied, the operator cannot operate a quarry in the state of Tennessee. And as part of that permitting process, TDEC can say, well, you say you want to operate your quarry in this way, but we're going to say that you have to operate it in a different way. And the permits that are received are it's not a single piece of paper, it's tens of pieces of paper that have details about how that quarry may be operated. And if that permit application is granted, quarries still have to comply with the specific terms of how their quarry may be operated. So it's a different regulatory scheme than something that has a bunch of regulations that set forth specific standards for individual industries. It's done through the permitting process.
But those, to the extent a quarry is subject to permitting requirements and has to comply with all of the things that go along with that, I mean, those permits only govern certain aspects of the quarry's activities, right? I mean, it's going to deal with water and air quality, but those permits are not going to detail, what hours the quarry may operate so that the trucks that are going down the road, are not going to disturb neighboring properties. A broad interpretation, it seems to me, would really preclude local governments from addressing other aspects of the activities that are not governed by the permits, which address really discrete parts of the activity.
I want to address a couple of points there, Your Honor. The first is that TDEC certainly could put in operating hour limits as part of the quarry is only permitted to operate for a certain number of hours per month or engage in certain activities for a certain number of hours per month. That certainly could be a part of the process.
But that would be to address, water or air quality, not to address, the sort of nuisance effects on neighboring properties.
But the other thing embedded in this too is that the resolutions don't provide operating hour limitations, and they don't provide limitations on where traffic can be. They create areas where quarrying is allowed and where quarrying isn't allowed. So if they are affecting quarrying itself in the county, and quarrying is on the record and based on the information that has been cited in the briefs, certainly an activity that is subject to regulation pursuant to clean air and clean water. Again, if the language is broad, it's because that's how the General Assembly drafted it.
So, Mr. Catone, I didn't mean to interrupt you. I'm curious about the natural effect of your argument. Is your position that this resolution that Grundy County passed is void?
Yes, Your Honor.
It's of no legal effect?
Yes, Your Honor.
They had no authority to do that because of the provisions of state law?
Yes, Your Honor. I think, and for two reasons. One is because they did not have any authority to regulate quarrying, rock crushing, or gravel pits, because those are all activities that are subject to regulation pursuant to the Clean Air and Clean Water. But there's also an additional reason which goes to the substantial effects test, which I can discuss.
And I'm sure that you're probably going to get many questions from the court about the substantial effects test. But as a hypothetical matter, if Grundy County passed a resolution that said you can't shoot a gun in this area of the county, is that void?
No, Your Honor, I don't think it is.
Okay, there's not state law that impacts that, as
I don't
far as you
believe,
know?
I don't believe shooting a gun is a business activity or use of property that's subject to regulation under any of those regulatory schemes that are enumerated in C2.
Okay, so the position is they can have a resolution prohibiting shooting a gun in certain areas of the county, but they cannot have a resolution about the location of a quarry.
Yes, Your Honor.
What effect does Dillon's rule have on our interpretation of the applicable statutes in this case?
Yes, Your Honor. So I think this court can apply the first charge always, before applying any statutory canons of construction, is always to give a reasonable interpretation to the meaning of the words that the General Assembly used. If it's unambiguous, I don't think there's any need to cite any further canon of statutory construction. But Dillon's rule, if the court does have uncertainty and wants to apply a canon of construction to aid in its interpretation of the statute, the one provided by Dillon's rule is the correct one. And it says, because local governments in Tennessee are governments that can only exercise those delegated powers, we presume that the General Assembly provided authority to local governments in clear terms and provided all of the authority it intended to. And so what we are going to do as a result of that is we are going to apply a strict and narrow construction of local governmental authority. And here, if anything, I think under the plain meaning of the language of C2, the resolutions are void and invalid, but if there's any question about that, Dillon's rule removes all doubt.
So how does Dillon's rule apply, I guess, specifically to, is it C2? You know, it's a kind of an odd provision because it is kind of narrowing, it is an exception to a grant of authority. So would Dillon's rule say that we have to construe that exception to the grant of authority broadly?
Yes, so the way that Dillon's rule works is that it is saying that the scope of local governmental authority is strictly and narrowly construed. So yes, I think that's correct.
Since that provision narrows the scope, then we would, narrows the scope of authority anyway, then we would, I guess, give it a fulsome interpretation.
I think that's correct. I think that's correct.
Does it require ambiguity as a trigger for application of that rule?
I think the cardinal rule of statutory interpretation is that if there's no ambiguity in the statute, we apply the plain meaning of the terms that are used. But that being said, I think the reasoning behind Dillon's rule explains why it's so important, right? Is that this is a governmental structure question, right? If counties are unhappy with C2, if they think C2 should be worded differently than it is, they can go to the General Assembly and address that. The other issue...
So your interpretation then is that no county in Tennessee, urban counties, any county, can regulate anything about rock quarries or any other entity that might be tangentially related, tangentially regulated, that a rock quarry could be in an urban area located right in the middle of a highly populated area? I mean, is that, I'm trying to figure out where what the limiting principle is that you would acknowledge, and I'm not hearing one.
So, Your Honor, the first thing about tangentially related things, I think that is always going to be a fact and specific circumstance, right? Is something actually subject
What
to
is the limiting principle in what you're talking about? I'm not hearing it in any way. Under that interpretation, they wouldn't be able to do any kind of zoning, nothing.
Your Honor, that is a key point here. This is only dealing with the authorities under the County Powers Act. Zoning is something completely separate. So local governments are fully able to achieve, they're fully able to, through the statutory zoning process, which was not followed here, set up areas where quarrying is or is not allowed, or any other land use. The point here is that the General Assembly says you have to use zoning, and zoning wasn't used here. You can't use the police powers that are granted under the county, plain text of the County Powers Act, but also under this own court's substantial effects jurisprudence to do what is in effect zoning without the use of zoning
Is
process.
zoning a subset of police powers? I'm trying to figure out how it interrelates with.
Zoning is a separate statutory grant of authority to counties than the County Powers Act. So we're not even talking about when it comes to zoning, we're not talking about the limitations in C2 at all, because counties have a free hand to zone subject to the limitations in the zoning statutes.
So your position is that if Grundy County had chosen to undertake zoning generally, and then more specifically with regard to quarry locations and things of that nature, that the resolution at issue here could have been done had they followed the zoning requirements under the statute. Is that correct?
Absolutely, Your Honor. Absolutely. And I think that leads into the second reason that the resolutions are void and invalid, is because of the substantial effects test that's been adopted by this court. And the purpose of that test is that the court has recognized that we don't want local governments to subvert the statutorily mandated zoning procedures that provide protection to Tennessee landowners in the use of their property by labeling what is really a zoning ordinance an exercise of the police power. Because then the police power swallows zoning. The police power would swallow zoning in that case. And so Grundy County's argument in this case has been, well, the police powers that are granted to us under the County Powers Act are broad enough to cover the resolutions, but that misses the entire point of what the substantial effects test is about.
But the police powers are broader than zoning powers, aren't they?
Yes, Your Honor, but what this court has recognized in Cherokee and subsequent cases that deal with the substantial effects test is that, yes, the police powers are broadly worded, but because we have this separate zoning process that is higher, that has higher procedural protections, including public hearings instead of public notice.
But doesn't it just regulate that subset of the broader police powers? If you are exercising the part of police powers that constitutes zoning, you have to follow these procedures.
Yes, Your Honor. If what a county or a local government is doing in effect is zoning, then they are required to follow statutory zoning procedures.
And do you find that this case satisfies the two-part test in the Cherokee Country Club? I'm curious. Well, let me be more specific with my question. Grundy County did not have a comprehensive zoning plan. How does that affect our analysis under the Cherokee Country Club case?
I don't think it affects it at all, Your Honor, and the reason why is that the establishment of a comprehensive zoning plan is one of the procedural protections that are required under the zoning statutes. So if counties and local governments are allowed to get out or to avoid or sidestep the statutorily required zoning procedures by not following one of those procedures, that makes that would sort of allow the entire zoning process to be subverted from the beginning, which is exactly what this court said should not happen. And that was agreed to by the Court of Appeals in this case, and also that was agreed to in the Sandy Mush decision that this court has cited multiple times with approval. The fact that
the North Carolina case.
Yes, Your Honor. And
Smush.
Sandy Mush.
Mush.
It's we get very good case names every once in a while that are entertaining, and that's certainly one of them. The key question under the substantial effects test is, do the resolutions have the effect of making unzoned areas subject to zoning prior to the adoption of a zoning ordinance? And here they do. Under the two-part test that Your Honor mentioned from SNPCO, the first prong is, are they tantamount, or are the resolutions tantamount to zoning? And here they are. They create areas of the county in which some land use is allowed and areas in which it's not allowed. That's the core thing that zoning does. And moreover, the resolutions do that by referencing other types of property use, right? You have to stay 5,000 feet away from schools, residences, other types of property use. And it also creates those areas by referencing property lines and boundaries and recorded property records, other concepts that you would see in a zoning plan.
Is there anything that would stop Grundy County from enacting such a zoning ordinance about the quarries today?
Not that
Mooting this case and just going through the zoning procedures and enacting regulations today?
I do not know of anything that would stop Grundy County from doing that. I'm not sure whether that would moot the case necessarily. I think that would be more of a fact-specific inquiry.
But they would have to adopt a comprehensive zoning plan first, would they not?
They would.
And oftentimes, historically, rural counties have been reluctant to do that.
I'm sure that's true, and I'm sure there are many reasons for doing it. I would say that zoning plan can be as broad and as permissive as the county would want it to be. That comprehensive zoning plan could. It could essentially, in effect, say there are no uses that are prohibited except as specifically said. The second prong of the substantial effects test is whether or not the resolution significantly affect the use of property. Here, that's relatively easily met. They ban properties, they ban Tinsley's intended property use, and they ban certain enumerated property uses in areas of the county, and that obviously significantly affects the owner's use of its property. I see I'm running out of time here. I'm happy to answer any questions that the court may have additionally. Okay. Thank you.
It sounds like your position on the zoning issue is, yeah, this is zoning, but you didn't do it right. Grundy County, you didn't do it right, so the ordinance is invalid.
Yes, Your Honor. I would say the position is this is in effect zoning, and you didn't give property owners any of the procedural rights that they're entitled to by statute when engaging in zoning, like the right to be heard at multiple levels of review, the right for there to be stricter, the most important one is notice and enhanced public debate that come around with zoning. And those are things that the General Assembly has said are necessary before local governments decide to substantially affect the use of property. So, are there any, I'm sorry, Your Honor.
No, I was just, I'll let you answer the justice's question or encroach on your rebuttal time as you like.
If there are any other questions, I'm happy to answer them. Otherwise, we would ask the court to remand with instructions to grant in summary judgment in Tinsley's favor and enter an order declaring the resolutions to be void and invalid.
Thank you.
Thank you.
May it please the court, my name's Bill Reeder. I'm from the Coffee County Bar, and along with my long-term friend and law school classmate, J.D. Balluna, we're here proud to represent Grundy County in this case. Tinsley, first thing they said was Grundy County...
Are you the only party arguing, or is your time divided?
It's divided, 25 minutes for me and 10 minutes, I'm sorry, for the State Attorney General.
All right, great, thank you.
The first thing Tinsley said is Grundy County's got to point to a specific statutory grant of authority to enact this resolution. We'd have it. The County Powers Act lets Grundy County, if they properly adopt the resolutions, and there's no question but they did, have authority under 6.201.23 And that statute says, gives those powers the right to prescribe limits within which activities and nuisances may be located, essentially. That's all that's all Grundy County's resolution does. It doesn't go a step farther. There's two critical things that must be present for Grundy County to enact that resolution under that statute. First, it can only prescribe limits, and that's exactly what it did. It prescribed the limit with which you can locate quarries in relation to a school, church, or some other business. That's not dividing the county into zones or districts. The resolution specifically says that quarries can be operated anywhere in the unincorporated areas of Grundy County. That's all the authority they have is in the unincorporated areas. That's as far as it goes, except they're not permitted within these limits of these places.
And isn't that exception, except they're not permitted in these areas, you know, or within these distances? I mean, how is that not tantamount to zoning?
Because it does not.
But it's a location-based restriction, which is in essence zoning.
Well, they have the right to do that. They've given them that, the statute gives them that right to do that when it says you have the right to prescribe limits.
Well, let's talk about 118C2, because that of course narrows that grant of authority when the activities at issue are subject to regulation pursuant to some enumerated statute. So explain, I guess, in your view, why that is not, why the fact that some of the activities, the quarrying activities at issue here do require permits under the statutes that are specified in 118C2, how that doesn't mean this is carved out from section 118.
I think you have to do that in relation to look at Dillon's rule and the exception in tandem. Dillon's rule says you look at the grant. When you look at the grant, you got to strictly construe it. They can't go any further than what you've granted. Grundy County hasn't. They've simply prescribed the limit within which. The next rule of construction is exceptions are to be narrowly construed. Those are not separate and apart from each other. You use them in tandem. You first look at the grant to make sure they haven't exceeded the authority in the grant. Fine. Grundy County didn't. Then you look at the exceptions are narrowly construed to make sure that the grant is not swallowed up by the exception. In other words, you have to look at both of them to carve out the intent of the legislature. And that's exactly what's done here. The C2 exceptions do not, this resolution does not touch, the Water and Air Quality Acts do not touch the very things that make quarrying a nuisance in Grundy County.
Well, we're in the text of 118C2. You know, do you derive the principle that it has to be the core of the activity, or I can't remember the term you used, but where in the text are you getting that notion that it can't be that it's just, you know, some piece of the activity, but that it has to be the very heart of the activity at issue that is regulated pursuant to, or subject to regulation pursuant to statutes?
It says activities that are subject to regulation. Now, activities in relation to quarrying is blasting, extracting, crushing, all of that, the traffic, the noise, all of that causes that to be a nuisance to the surrounding neighbors is unregulated. And as the State Attorney General said in his brief, that carve-out only applies to the activities that are actually regulated. because that would have to be a broad interpretation, because if you look at that, under the Air Water Quality Act, the state requires a water permit if you clear more than 1 acre under the Water Quality Act. If you clear more than 1 acre of land, that you have to have a permit. That would encompass any activity almost that you can name if you had to go clear an acre of land. I know when we just built in addition to our house, we're kind of close to a lake, we had to put up a silk screen to make sure nothing went to the lake. But if you did that, if you take that as broadly as they want to say, any activity where you have to clear more than 1 acre of land to get it started, you got to get the permit, that would make that a regulated activity. For example, if they wanted to put a prison there and had to clear land, under Tinsley's interpretation, that would be a business regulated under the Air, Water, and Quality Act, and they couldn't do it. Well, that's...
Well, but, I mean, there's a I'm sorry.
That's okay.
Go ahead.
No, I was gonna shift gears a little bit, but Mr. Reader, you talked about Dillon's rule a little bit, and you seemed to indicate that it actually helped you in this case. I didn't quite understand that. Can you explain to me how assuming Dillon's rule applies, how that is helpful to the Grundy County position in this case?
What Dillon's rule says is that the power granted to a county or a local government has to be narrowly construed.
All right.
The statute says, let's give a very narrow construction of that the county can prescribe limits within which businesses liable to be nuisances may be operated and located. That narrow construction is exactly what the Grundy County resolution does. So
even though it addresses almost, it says 5,000 feet, which is obviously close to a mile.
Yes, sir.
In residence, school, licensed daycare, I mean, the whole laundry list, professional or industrial establishment. Is there any evidence in the record of what areas a quarry would be able to establish in under this resolution in Grundy County?
No, sir. And the reason, well, I guess there is, because Grundy County has over 10 billion square feet, and it's a very sparsely populated county, and there would be many areas where that would
Well, but I'm talking about in the record. Is there any discussion of, is there a viable location for any type of quarry in Grundy County under this resolution?
That would have been up to the plaintiffs to have raised that in the court if they were saying that it was an unreasonable. They did not. Okay. That was not an issue in the court. But Grundy County, to answer the question, I think there is ample proof there with over 10 billion square feet that there's areas that would accommodate a quarry.
Mr. Reader, let me ask you just kind of a core question in this
Yes,
case. All right, you got this ordinance. Can't put a quarry within 5,000 feet of certain things, certain churches or schools or whatever. Is that not a statement about how property is used in a specific area? Isn't that what that is?
Yes, sir. That would satisfy the second prong if you ever got to it. That does affect how that particular property can be used. But to make it zoning, it has to be tantamount to zoning. And as the State Attorney General pointed out in his brief, there are no zones created by this. It's very similar to the total prohibition of having fireworks that in the SNPCO case. And SNPCO specifically said that the first prong of that test is to determine where it's tantamount to zoning, and to do that, you have to look at the comprehensive zoning plan. Now, let me.
So
look-
there is no zoning in Grundy County? Is
Right.
that the argument? You can't, no zoning in Grundy County? Because Grundy County doesn't have a zoning plan. So whatever regulations about the use of the property in a certain area, is it your position can't be zoning then?
It's not zoning because it doesn't carve out areas, Your Honor.
Well, how does it not carve out areas? It carves out a 5,000
It does.
foot boundary
this-
around certain businesses and.
Well, it essentially, what that is essentially no more than a setback line, but they don't say that you can have in this area of the county, a zone, commercial zone, you can have a quarry, but in the residential you can't. They don't set forth any type of.
I'm sorry, Mr. Reader, but wouldn't you, if you are the quarry owner and you're trying to figure out in relation to this where you can locate, wouldn't you necessarily be drawing yourself a map and putting boundaries in certain areas to try to figure out where you could locate? Isn't that effectively what you would have to do?
Not really. I don't think you would have to draw a map and do that. You would just have to know, you can look at tax records or whatever and see that the property I'm buying is not within 5,000 feet of.
Well, but isn't
But
that making a map? If you're looking at the property tax, if you look at the property tax records and everything else, you're essentially making, you may not be sitting there drawing it out, but you're making a map, aren't you?
But you haven't created a zone. Otherwise, why would the legislature have said that you could prescribe limits within which they can be operated? You're not creating a zone, you're just prescribing a limit. And to that point, I think it's good to look now at the legislative history of the County Powers Act. When you look at that, in 2002 is when the first time they extended essentially the police powers under the County Powers Act. It was only given to counties without zoning ordinances. And when the legislature did that, it was obvious that they recognized that there are a lot of counties that don't have zoning ordinances. So we're going to give them this police power to protect their citizens from nuisances. It doesn't give them the broad power to zone and say certain things can be done here, certain things can be done here, and certain things can be done here. It only gives them that power to prescribe limits within which nuisances may be located.
But it says certain things can't be done here, and they can't be done here, and they can't be done here. So how is it different? Just because it's saying what can't be done in a certain area.
The limits are
zoning would say what can't be done also, but when a zoning ordinance, if it says these are the permitted uses, things that are not within that permission fall outside of it. This only prescribes a limit within which they can be operated close to a house or a school or a church or something.
Well, and Mr. Reader, I think that's what I'm struggling with, right? You say that local governments, have the ability pursuant to this police power provision to prescribe limits, but here the limits that have been prescribed are location-based limits. It's not limits on, the times of the day when certain activities may be conducted. I mean, it's limits on the location where the activities may occur, and I'm just really having trouble understanding how that is not tantamount to zoning if it is a location-based limit.
Well, limits there is not defined as time or anything of that nature. It just said prescribe limits within. When you talk about limits within, to me, that means that you have the right to say, you can operate this or can't do this within this area, within
So you're creating a zone?
No,
I mean, when
no,
you're
no,
saying,
I-
when
I
you're
don't mean to say I'm creating a zone. What I'm saying is, it's a distance within relation to some other thing.
which
but-
creates a zone within which that limit applies.
But it has been held that several Attorney General's opinions during that time said, by doing this, the legislature created a means other than zoning by which counties may regulate land use.
Let me ask you this. So, one of your arguments seems to be that, look, if local governments can't do this, then we're really going to be at a loss for dealing with these problems. Why aren't nuisance actions an alternative way to remedy, whatever problems were sought to be remedied with this, with this ordinance?
Well, a lot of it would be practical because a lot of people that live in this area would not have the means to employ an attorney to do that.
Could the county bring a nuisance action?
Well, the county could bring a nuisance actions, but they're given the authority to prevent nuisance on the front end, and there's no question that this quarry is a nuisance. When you look at the evidence in this case and the law that's been held, that quarry.
Is there anything that would prevent your client from effectively doing the same thing by following the zoning process?
Well, first of all, it'd be difficult without a zoning process to have the resolution presented to planning commission, because if you don't have a zoning law, you would not have a planning commission to submit it to. But the way for enactment that you look to in the statute is it specifically defines the way it's to be enacted, and that is with a 2/3 vote of the county legislative body. That's the added safeguard there. It prescribes how they are to be enacted. If the legislature had intended that you can enact these measures, you can prescribe these limits if you but you have to follow the zoning procedure, they would have said that, but they did not say that. They said you do it by a 2/3 vote of the legislature.
Are you arguing that even if it is tantamount to zoning, the county still has authority under the police power to do this?
First of all, I don't think it's tantamount to zoning.
I understand that.
But let's say that if it was tantamount to zoning, I would think that under the test of SNPCO, I think they do, because they do not have zoning. SNPCO specifically says that the first part of the test is to see how it relates to the overall zoning in effect, the overall zoning plan. And there's not an overall zoning
You remember
plan.
my hypothetical, if you don't have a zoning plan, but it is still tantamount to zoning, and we hold that that's the test, are you saying you still have authority under the police powers?
Yes, ma'am.
Okay.
I think under that we would, because of the specific grant of the power under the police power. And the legislative history. When you follow the legislative history, it is clear that they intended to give this power to counties without zoning ordinances, because that's the first counties they gave it to, counties without zoning ordinances, which naturally says they realize that these resolutions are going to be adopted outside of the zoning. The Attorney General's office in 2 separate opinions has recognized that.
Well, I guess I'm a little confused now, because I thought I heard you earlier say that you would agree that if the substantial effects test applies, that the second prong of it here is met.
The second prong, not the first.
Right, okay. But now Justice Wagner's question was, even if, let's assume that it's tantamount to zoning. Well, that's the first prong of the substantial effects test. So, but yet you're saying, even if it is tantamount to zoning, it's still legal. I mean, I'm having a difficult time reconciling the point of if that two-part test applies, and you said it clearly that the property owners can clearly satisfy the second test. Now we're under the hypothetical that it is tantamount to zoning. How does that not completely satisfy the substantial effects test and make it illegal?
Well, if I had to assume that it met the tantamount to zoning, it's difficult under SNPCO to reconcile that case with a case where there is no zoning. I mean, zoning encompasses a whole lot more than just saying, prescribing a limitation within which something can be located. It sets forth permissive uses and various things other than just one thing. And this law does not do, this resolution does not do that, Your Honor.
What things does it not do that makes this not zoning?
Well, it doesn't carve out specific zones. And I think the Attorney General's brief really showed that to have zoning, the first thing you have to have are zones.
Okay, anything else?
Yes, because then when you go to zoning, it'll set forth other things like it can state, like in residential areas, that they've got to be so many square feet in a house. They can set forth a lot of specifics. You got to have 50 feet of right of way to get to it. Okay. You've got to have easements, setback lines, all that kind of thing goes into zoning. This doesn't do that. It just says, you know, if you're going to operate a quarry, don't operate it in these people's backyards. That's all that it does.
Do you have a sense of, if we were to hold that this is, in effect, zoning, do you have a sense of how many counties would be affected by such a holding?
The last count we had would be around half, 47. They were cited in the brief. And
have ordinances like
47 counties in the state, as of 2014, did not have a zoning ordinance.
Okay.
Mr. Reader, let me ask you something that was unclear to me in the record that I'm curious about. So Tinsley applied for a permit, correct?
With Grundy County?
Yes.
No, sir, not initially. This is what happened.
I'm glad I asked you that question.
Okay.
So tell me what happened.
Tinsley never initially applied for a permit. They just started their activity over there without asking anybody from the county anything. In fact, they started their activity before they even applied to the state for the water permit. But in any event, they started their activities over there, excavating and doing things, getting ready to operate the sand quarry. People from the area contacted the mayor, said, what about this? What about our resolution? Well, the mayor looked to it and found, well, yeah, they're in violation of that, because not only are 5,000 feet, they're right up next to property lines. You couldn't have drawn one, Justice Blevins, any feet that they would have complied with, because they abut other ones. But in any event, they started. Then the mayor sent them a letter telling them to cease and desist. They still did not apply. They went to they filed a declaratory judgment action in court. Then later they did apply, or when we set forth in our answer to the complaint that they hadn't even made application, they wanted to do a belated application, and which we agreed that they would not have to come before the county commission at this late date, since the matter was already in litigation, because it had been determined, the county had determined they were going to resist it. And the only issue would have been was whether or not they were within the distance limitation. So it was stipulated that we would waive that part of it since the matter was already in litigation.
May I ask one more question? I'm sorry, Mr. Ritter, I know your time's up, but I have a question I really want to go back to. You indicated earlier that there was evidence in the record regarding that this, in fact, was a nuisance. My understanding was this was resolved on summary judgment. So is there actually in this record evidence of this particular location being a nuisance?
Yes, sir. If you look at their response to our statement of material facts.
Okay.
And I think that'd be on volume 5, page, maybe off on the pages around 728 or 729. Their response, I set out the elements of, admit that this would, the elements of a nuisance,
Okay.
and they admitted it for the purposes of this litigation. So yes, sir, there is.
For purposes of the motion?
Mm-hmm. They did. They admitted that for purposes of litigation.
Any other questions?
Thank you.
You have used your time. Thank you very much. General?
Good morning, Your Honors. May it please the Court, Gabriel Krim for the people in the state of Tennessee. Your Honors, this case is about Grundy County's prerogative to govern matters within Grundy County, as allowed by the General Assembly and without undue interference from the courts. And I would like to just start with the justiciability issue we raised in Part 3 of our brief, because I recognize the state introduced that issue, and although Tinsley responded to it in their briefing, we think it's been misconstrued, and so I just want to set the record straight. They can get a declaratory judgment. What they can't get is an advisory opinion. And there's a very important difference between the two. We think this court has addressed that in cases like Brown and Williamson. We think this is consistent with federal jurisprudence in this area. And the bottom line here is courts, the judicial power, decides disputes between parties regarding concrete circumstances. Okay, so relief, even declaratory relief, has to be party specific, meaning it has to pertain to Grundy County and Tinsley properties in this case. It has to concern concrete circumstances, the use of this land for quarrying in this case, and whether or not that can be permitted by the county. It has to be provision specific. There's a lot of debate about the setback requirement. Well, if we're on the question of the setback requirement, and that's a zoning, if the court were to hold that that's a zoning requirement and can't be enforced, that doesn't mean the rest of the permitting requirement is invalid. The county could still permit on bases other than setback. So that's just an example of what I'm talking about with provision specific. And then of course the relief has to be tailored to all of those circumstances in this dispute. So your declaratory judgment in this case, I heard my friend on the other side say at the beginning and at the end, the resolutions are void and invalid. That's not the form of declaratory relief that's available. The form of relief that's available is this permitting requirement cannot be applied or enforced against Tinsley properties with respect to this particular quarry. Now, of course,
would we have to engage in any sort of severability analysis?
I'm not so sure that that's necessary, Your Honor. I think the question is just the extent to which the permitting requirement can be enforced. And I'm sorry if I can't recall off the top of my head whether the permitting requirement has a severability clause. I think it may have one. And that might be appropriate, but I don't think that multiple terms are really at issue here, so I'm not sure that that would be necessary. I do also just want to make clear that this isn't to take away from the value of precedent. Of course, if the court's reasoning in this case that settles the dispute between these parties applies to other parties that aren't before the court in this case, then it will be useful as a matter of precedent in the under the principle that like cases be treated alike. But fundamentally, the judicial power is about disputes between parties, and it goes back to Marbury versus Madison. You have to look into the validity of the laws that you're going to apply, and so that's where this whole concept of declaratory relief comes from. Moving on to the County Powers Act issue, I just want to make clear that the court here is choosing between multiple textual approaches to reading this particular language. And I know that a number of statutory, canons of construction have come up here. I think we agree with the other side that the basic principle here is find the natural, the ordinary meaning of the text. And our point here is, when you're doing that, you have to look at all of the text. You can't just look at the term activity. You have to look at the term activity in relation to business, use of property, business practice. You have to read those terms so it's not a superfluous list. And we also think that you have to look at this term subject to regulation under these enumerated regimes and then, consider what is actually being regulated under those regimes. So principally what you have is a level of generality problem, right? I think that's what the bench is really struggling with here, is Tinsley wants to say, we engage in quarrying, that's the activity or that's the business, and it's subject to regulation in the sense that our water discharges are permitted by the state. And our point is that's a mismatch of the level of generality. The one real way that you know this is that the state has a surface mining law that permits quarrying in the state's most populous counties, sand and gravel quarrying. And that's a more comprehensive regime that's under Title 58, Chapter 8, Part 2. They would have to get a permit for quarrying itself if they fell under that regime. They don't fall under that regime. It doesn't apply to sand and gravel quarrying in Grundy County, which is why they're raising the water quality control permits as the basis for why they can be exempt from county permitting. Again, we say that's a mismatch. We also think there's another structural inference you can draw from another part of the statute, that's TCA 51118B, wherein the General Assembly said that nothing in the County Powers Act shall be construed as empowering counties to regulate normal agricultural activities. That's a broad exemption from county regulation of an entire industry, an entire business. Basically, anything that falls within normal agricultural activities can't be touched by the County Powers Act. That's what Tinsley wants for quarrying in this case. We think if the General Assembly had wanted that for quarrying, they would have done it in a way similar to the way they've done for agriculture. So again, the point here is you don't just look at a term activity in isolation. You look at all of the text. You think about what's the natural, ordinary meaning. What's the meaning that doesn't have, we have this problem with superfluity. We have a problem with perhaps the exception swallowing the rule in this case. That's another canon. If we want to talk about Dillon's rule, construe, grants of power narrowly. Well, the grant of power is worded as broadly as possible in this case, and we're arguing about the exception to the grant, usually exceptions.
How does Dillon's rule apply to our interpretation of the exception from the grant of authority?
I don't think this court has ever made clear whether or not Dillon's rule takes a comprehensive approach to grants and exceptions and treats them all as one thing, or whether it just applies to grants.
Wouldn't it sort of have to apply to both? It would seem a little bit hyper-technical to not apply Dillon's rule to the exception simply because it's an exception when the statute could have been drafted so that the exception is sort of wrapped into the grant of authority, and in that situation, Dillon's rule would apply, I think would be your position, but why wouldn't, you argued a moment ago that we sort of have to look at a statute sort of as a whole, but, with respect to the application of Dillon's rule, wouldn't that same principle apply, that we kind of have to look at the overall effect of the statute? What power is it granting when you take into account, both the provisions that expressly grant authority and those that accept things from that grant of authority?
Well, perhaps, but I'm not sure that there's anything in this court's precedent to indicate that Dillon's rule is a stronger rule of statutory construction than the general rule that you construe exceptions narrowly, or even these other, rules about reasoning from the structure of the statute or comparing different parts of text, and the idea that if text is different in one area of statute from another, then it carries a different meaning. These are all tools in the toolkit of good statutory interpretation. If the court wants to provide guidance about a hierarchy of these, I think the state would welcome that, but I don't think it exists in the court's jurisprudence to begin with. I also don't think it's necessary to resolve this case. I think all of your contextual clues really point you to the same to the same point in this case, which is, it's just a strange way of exempting quarrying and leaving it basically not subject to regulation at all on the state level or county level, to do it in this way of, well, we've granted you a water quality permit, and therefore, because that's necessary to operate a quarry, we're just not going to regulate quarrying in the.
Yeah, let me ask you a little bit more about 118C2 and your reading of that. I mean, I take your point that, Tinsley's view on the interpretation of that provision may be a little too general, a little too broad, and it could, lead to a situation where virtually everything is accepted from an otherwise broad grant of authority. I've read your brief and sort of how you propose to interpret that provision, but I'm wondering if you can provide maybe some concrete examples of, things that would be covered by the exception, just to help us understand how that interpretation may apply in practice. Because we don't want to interpret it too broadly. We of course want to give it a reasonable meaning, but we also don't want to interpret it so narrowly that it doesn't apply to anything, so that you have to have a statute that specifies that it is regulating precisely the activity that is at issue. There's got to be some middle ground. So do you have any, concrete examples of things that would be covered?
So we've provided that would be exempt from regulation because they're already being regulated on the state level. It's very difficult to provide these examples. I'll just let the court know. We're talking about statutes that deal with air quality, water quality, oil and gas, alcohol, mines and mining. They also have their own little carve-outs within them, sometimes to allow police power from the counties in certain situations. I don't know that this court has ever really addressed what wins out in that circumstance, whether the carve-out or not. But I think the general point here is, for instance, when in this case, you have environmental regulation, right? Many of our environmental statutes set both a ceiling and a floor for, pollution discharge. And I think the point of this statute and these carve-outs is to say, well, when the state sets a ceiling and a floor, the county can't come in and raise the floor. It's difficult for me to point to a specific area where that's happening, partly because in some instances there isn't a ceiling and a floor because of the carve-outs I just mentioned within the statutes themselves. But again, you have such broad forms of activity being regulated here. Sale of alcohol, I think, is really a big one in that that's very comprehensive. But by virtue of the fact that it's so ubiquitous, it's difficult to look at the alcohol regulations on the state level and say, well, selling alcohol is regulated and therefore everything else I do in my restaurant or in my bar or my business, whatever, is not subject to county level regulation. I think that's the real struggle here that the court is dealing with. I won't pretend that this is a clearly worded statute. I mean, I think the court has a lot of good questions about this statute because it isn't terribly artfully drafted. And that these regulations.
You have used your time, but I'll give you another minute to address the zoning issue to the extent that a minute or two.
Yes, thanks very much, Your Honor. I truly appreciate that. I do think that the zoning issues in this case are really foreclosed by the SNPCO case that everyone's talking about. And I think it's important to recognize that the argument that Tinsley is raising here about the substantial effects test is precisely the argument that the court rejected in the SNPCO case, wherein the court said that the lower courts had been erring by focusing chiefly on whether the challenged ordinance substantially affected the use of property without analyzing the extent to which the challenged ordinance was so closely related to the city's zoning plan that it should be considered tantamount to zoning. Courts must first determine whether the challenge ordinance relates to the city's general plan of zoning. Then and only then, those are the key terms, then and only then may courts ascertain whether the ordinance results in a substantial interference with the use of land. Both parts of the test must be satisfied for a challenge ordinance to be held tantamount to zoning. We think that addresses the whole issue with the substantial effects test in this case. We pointed to the Goodell case from Iowa, which
So
says,
if a county does not have a comprehensive zoning plan, it's just free reign, cannot apply.
we think that that is a fair reading of SNPCO. If the court isn't, inclined towards that reading, we think it's important that the court recognize and reaffirm that the hallmark of zoning is not land use regulation, nor is it location-based regulation as kind of an abstract principle. It is the drawing of fixed lines on the map. that do not depend or move or change based on how anyone else is using their property. Setbacks have existed for decades. We've cited a number of cases from the Pennsylvania Commonwealth Court specifically dealing with setback requirements and how they differ from zoning. You can't just say that a setback requirement is zoning, because in a setback requirement, the lines are dynamic. They change based on what other people are doing with their property. And when you're doing zoning, the lines are fixed. That's why zoning has the procedural protections that it does, is because there's nothing you can do to change how your property is zoned, or for anybody else to change how your property is zoned, short of government action. With a setback, that's not the case. With a setback, it depends on your neighbors and what they're doing, and so.
All right.
Chief.
Any other questions? Yes.
General Krim, I found the last part of your argument enlightening. Thank you. It's good to know what the state's position is on that. I'm troubled a bit about the statement in response to Chief Justice Kirby's question. If there is no comprehensive zoning plan, then it must not be zoning. I think that's what I heard you say, and I just wondered how our decision in the Cherokee Country Club affects that part of your argument.
Mm-hmm. Well, I think that the Snipco case, again, distinguishes Cherokee Country Club in the way that's applicable to this case. But in Cherokee Country Club, you were dealing with a city that had zones and had historic districts. And what they were trying to do was prevent a non-conforming use from getting grandfathered in. Now, as I just said, if you want to change your zoning plan, you have to go through the same procedural rules that you use to enact the zoning plan. And so sometimes you have these situations where a locality is going through those procedural requirements, but feels that it can't work fast enough, and so tries to impose a stopgap. And that's what you have in the Sandy Mush case and in the Cherokee Country Club case. And what courts have said in those instances, including this court, is you can't do that. You cannot skip and adjust the zoning plan by skipping the procedural safeguards and preventing these non-conforming uses. So, unless there are any more questions, I appreciate the court being very gracious with the time today, and I thank the court for the invitation. It's been a pleasure on behalf of the state.
Thank you.
Thank you.
Your Honors, I'd like to jump right back into that last point there about, does it matter whether the local government has adopted a zoning plan or not? And
Well, let me ask you first, though. To the General's point about zoning being fixed lines, the quarry here, for example, if it is limited by the location of a church, it could change that. It could go in and go to the church and say, we want to buy your property. Church sells it, boom. So there's no zoning map that is fixed in place. It is in relation to how other people use their property. That's not really a signature of zoning, that you would be able to go in and if you can affect how other people are using their property, you can move the areas in which your client could operate.
well, Your Honor, I haven't seen a substantial effects test case that draws that distinction. What I have seen is Sandy Mush and the Florida cases that Cherokee relied on, and those provisions that were issued.
So what do you say to that distinction, though?
That distinction, I don't think it matters for purposes of the substantial effects test, because it's just another way of creating zones.
But true zoning actually is fixed, and it's beyond this line. You cannot engage in this use. Doesn't matter what people on the other side of the line are doing. Beyond this line, you can't engage in this use.
Regular zoning, people can, allows property owners to go and petition for their property to be rezoned as well. They're not fixed once and forever. Things are
But
rezoned
you have to
all
go
of the
through
times.
the zoning process to change it. That's not true here. That's not true here. Your client, if they can affect how other people nearby are using their land, they can in fact broaden the area in which they can operate. That's not consistent with zoning.
I think it certainly is, because there are these types of provisions like the setback requirement here that are adopted in zoning resolutions or in zoning ordinances all of the time. Setbacks are a feature of zoning, right? Now, maybe it's not the only feature of zoning, but it is a feature of zoning. And if you look at the effect of what is actually happening with these resolutions, I mean, it was said before, you can sit down with a map of the property tax map in Grundy County and a ruler and the text of the regulations, and you can draw all the areas in which quarrying is allowed and where it isn't. And that is zoning.
But if some of the neighbors change the use of the property, then that map is going to be fluid. And that's not a signature of zoning.
I've done zoning work for a lot of different clients before, and have spent many days in front of the Board of Zoning Appeals asking for variances and changes, and part of that is that's part of the process of zoning, is to allow for that process. There's nowhere for Tinsley or anyone else to go to have a zoning appeal or ask for rezoning under the ordinance, because the zoning procedures and protections weren't followed in the first instance. And to draw a finer point on this, the provisions in Sandy Mush and in those Florida cases that were held invalid under the substantial effects test were every bit as fluid as the resolutions were here. In the Florida cases, the examples were establishing minimum distances between businesses selling alcohol and residential areas. That was held to be zoning. Prohibiting the construction of homes near an airport. That was held to be zoning, right? And in Sandy Mush, it was a 2,000-foot limit on heavy industry between a church, school, residence, or other structure that was challenged by a quarry, and that was held to be invalid under substantial effects. Those all look exactly like what the resolutions are doing in this case. I want to address a point about the appropriate remedy here, right? And I'm quoting from the City of Lebanon versus Baird decision from this court. It is well settled that a municipal ordinance may be declared void when not passed regularly or according to the forms of law, right? That's a power that this court has recognized that it has time and time again, right? If a resolution was not passed, or a local government enactment was not passed appropriately, if it exceeded the local government's authority, it's void ab initio. And of course this court has the authority to declare that to be so.
But we also try to tailor the remedy to make it as limited as possible. And you're asking for a very broad remedy that goes well beyond affecting your client.
Well, Your Honor, I think that in this particular case, that what is going on is that the setback requirement is the requirement. There's no other basis on which a permit would be issued or denied. So the idea that there would be a separate permitting process under the resolutions that could survive just doesn't exist. This was a statute that was, the resolutions were intended to draw these areas where certain property use is allowed and other property use isn't allowed. And if that is invalid, if that exceeded the county's powers, then really there's nothing left. There's not some other sort of mysterious thing that Tinsley would have to comply with that now it doesn't because the whole thing has been declared invalid. We're challenging the core part of this resolution. I want to talk for a moment about this idea between how exceptions should be construed or limitations should be construed. The leading first of all, I don't think C2 is a classic exception. I think it's a limitation that the General Assembly has placed upon counties' powers. And the leading treatise in this area, Reading Law, that was written in part by Justice Scalia, that this court cited multiple times, really has an insightful point on this, right? The idea that you would construe an exception differently than the main provision of a statute doesn't make any sense, because the exception or the limitation is every bit as much a part of the statute as the grant itself. And that's especially important here if you're considering Dillon's rule in the context here, because as Justice Campbell pointed out, this statute could have been worded differently and it would look less like an exception than it does now, but that wouldn't change the content of it. But more importantly, we're talking about the scope of local government power, right? And that's what this court said in Southern Contractors, Inc., right? That the canon of statutory construction under Dillon's rule calls for the strict and narrow construction of local government authority, not the provision granting power, but not an exception or a limitation. I think that that's a distinction without a difference in my mind, and I think under the law as well. There was also a comparison that was made saying that subsection B of 5-1-118 is different. If you look at that provision, it deals with agricultural practices. Well, the reason it's worded differently is because agricultural practices are not businesses, activities, uses of property that are subject to regulation under those enumerated statutes. They're not. So, of course, there's a separate provision for that. And what C2 says, right, is those languages, activities, businesses, uses of property, business occupations or practices, those are language, those words come specifically from 6-2-201, 22, and 23, right, which are the powers that were previously granted to municipalities that the General Assembly applied to counties subject to those limitations. But that language, that's the context. Anything that a county is allowed to do in 22 and 23, it can't do with respect to things that are subject to regulation under clean air, clean water, or all of the other regulatory regimes that are cited in C2. If your honors have any further questions, I'm happy to answer them. Otherwise, we would ask for the court to remand with instructions to grant summary judgment in Tinsley's favor and enter an order declaring the resolutions to be void and invalid. Thank you.
Thank you. Thank you both for your good arguments. We appreciate them very much. We won't take a break. We'll give a minute, though, for anybody to leave who wants to leave.